Morning, everyone. My name is Haifa Khatib. I'm a marketing assistant here at InfoTrack. Today, I'm joined by Ian Quayle of IQ Legal Training, who will be going through our webinar, Acting for Lenders, Tips, Traps, and Recent Developments. I'm also joined by our product manager here at InfoTrack, Annabella Barker, who will be going through the ways that you can circumvent any of these issues that you deal with and anything that Ian Quayle has covered and how we can apply that with the InfoTrack platform. Just a bit of housekeeping before we begin. We have a Q&A tab at the bottom of the screen. If you have any questions, please do submit them into the Q&A tab, and Ian will answer them perhaps throughout the session, and then some of them will be answered at the end of the session. This webinar is also being recorded, so if you do have, if you would like the recording post the session, I will send that over the following day. So that is everything from me. I'm just going to hand you all over to Ian.
Thank you. Thanks very much. Good morning, everyone. And a massive thank you to InfoTrack for organising today's event. Hopefully you're sitting comfortably and you can see the slides and hear me. I'm going to turn my camera off because you don't want to see me, and it does affect sometimes the quality of the connection, so I'll turn that off for a little while. As we were saying earlier, as far as questions are concerned, I'm happy to take questions at any stage as the webinar progresses, and I'm also more than happy to deal with any questions that arise as a consequence. So if you have any questions or queries in connection with anything that I have to say, then do feel free to drop me a note, and I'll share with InfoTrack the questions. I'll anonymize them, obviously, together with any responses. So thanks, Haifa, for the introduction. It's very kind of you to explain, and Haifa will be looking after the sort of the techie side of things as the webinar progresses. So let's have a look. There's a lot to talk about today in connection with recent developments, so let's go through them. First of all, some very, very useful websites that I always mention to practitioners. The PLA website is brilliant because there's a case law update section, and in addition to that, lots of barristers and cases, as they're now called, write papers and opinions that you can access. We're not litigators, we're transactional property lawyers. I'm not for the life of me saying that we become embroiled in litigation, a very dangerous thing to do as a transactional property lawyer. But if we want information on cases, we want to know about easements or restrictive covenants or Section 84 applications related to covenants, etc. Wealth of material on the PLA website. City of London Law Society Landlord Committee, useful if you're a nerd like me and you want to know about what's happening in connection with law reform. The City of London Law Society Landlord Subcommittee is pretty impressive, to be honest with you, in that they tend to spot issues such as electronic verification of documents very early on, and will come up with protocols and ideas, etc., which ultimately can find their way into the sort of realms of residential conveyancing. Property protocols, boundary dispute, boundary issue protocol, very useful if you've got boundary sensitivity issues in conveyancing transactions. RICS website, survey and valuation, a consumer guide to survey and valuation. Important to provide clients with the need for and the significance of survey of valuation independent of the lender's valuation. The RICS consumer guide to survey and valuation, which you can download free of charge, will assist you with regard to explaining to clients the different types of survey and valuation and the merits in obtaining a level 3 survey and valuation in connection with a residential purchase. The last 3 websites that I mentioned are all connected to leasehold transactions. And one of the things I'm going to be sharing with you this morning are some issues with regard to lenders and leaseholds. To be honest with you, I can spend an afternoon talking about lending issues and leasehold properties, but I'm going to share with you some views in connection with the Building Safety Act. A caveat, however, and a word of warning: the Building Safety Act is a vast piece of legislation. Its consequences are significant, whether you're acting for landlords or leaseholders, whether you're a transactional property lawyer or you're involved in leasehold management. And to be honest with you, a lot of the legislation generates more questions than answers. Which is unfortunate. The Leasehold Advisory Service website has a lot of information about the bigger picture concerning leasehold ownership, also provides advice and guidance for leaseholders and their advisors with regard to things like the right to manage, collective enfranchisement, the right to extend, etc., etc. The Association of Residential Managing Agents also has guidance in connection with leasehold ownership for clients and some useful information, peculiarly on estate rent charges and also on an LPE1, landlords' replies to inquiries, which is quite interesting. And the Leasehold Knowledge Partnership, quite a political organisation, very supportive of leaseholders, particularly in connection with fire safety issues, but it has news and it has guidance in connection with all manner of different things. The one unfortunate thing for our purposes today is that all three organisations haven't as yet provided a sort of definitive guide to the Building Safety Act and its implications. And I keep hoping and praying that they will, or that the Law Society will, produce such information so that we know where we stand with regard to the Building Safety Act. At this moment in time, I'm talking to practitioners who are saying we're not acting on leasehold transactions at the moment, given the potential problems associated with the Act. Just to let you know that I am later in this month doing a webinar with some barristers from Tanfield Chambers, where hopefully we'll have some more answers to the problems. What we're going to be doing today is just highlighting what the problems are and just generating awareness for practitioners with regard to those problems. So all those sites are free to access. They're all useful, to be honest with you, in various degrees. Firstly, I want to talk about our issues associated with due diligence and lenders. And of course, checking lenders' requirements, and also now, courtesy of CQS, changes to guidance as of the May 2022, we're now obliged to check lenders' instructions just before we exchange contracts to see if those instructions have changed. A number of things with regard to lenders' instructions. Lenders' handbook does alter from time to time. Alterations are frequently administrative and minor, but from time to time they are significant, and therefore it's important that you keep lenders' instructions under review. It's also important, I think, that we look at due diligence from a lender's perspective, which is the first part of my presentation today. Then what I want to do is have a think about how we report to lenders and what we say to lenders and issues ancillary to those points. We'll have a look at how we deal with searches and reports that are obtained that may have consequences for lenders. And then I want to drill down, if I may, before Annabella does her presentation, to talk a little bit about estate rent charges, which are a bit of a thorn for conveyancers and potentially problematical for lenders, and also the Building Safety Act 2022 and the current state of play with regard to that act, in particular with regard to lenders' instructions. So lots to talk about. We will, as Faye was saying, building a little bit of time at the end of the presentation to deal with questions. If we don't have time, then as I say, I'll endeavour to deal with questions at a later date. So let's talk about title investigation. There are notes that accompany today's presentation in which I discuss good title and marketable title. A lender is reliant on you to determine that a title is good and marketable. A marketable title is better than a good title, and in essence is a title that a reasonable conveyancer would be willing to accept on behalf of their client. There are some practical issues relating to registered land that I think are important. Firstly, with regard to leasehold titles can be an absolute title, granted an absolute title by the land registry, but are not necessarily good and marketable titles. It's always important to check the leasehold title if it's an absolute leasehold, and to check the property register to see if there's any reference in the property register to whether the land registry has investigated superior title to determine whether or not a lender's consent or a landlord's consent with regard to the granting of the lease. Prior to, I think it was June 2006, the land registry would always check the superior title out of which a lease was derived, and would then check to see if a landlord's consent or a lender's consent was necessary, whether that consent had been provided. If it hadn't, they would award a good leasehold. Because of complaints back in the day relating to that process, the land registry changed its process and will now grant an absolute title, but will put a warning in the property register to the effect that they have not checked whether landlord or lender's consent was granted in connection with the creation of the lease as required by the superior title. So always watch out for that. It's not something that is commonly encountered, but I have seen practitioners get themselves into a bit of a pickle on the basis that they look at the leasehold and think it's an absolute leasehold, therefore everything is fine, and not reading the property register or not understanding what the warning in the property register is designed to do. In any event, I would always maintain, whether acting for a lender or a lay client, when dealing with a leasehold title, you should also always check the superior title out of which the lease is derived, and where the title requires a consent, you should check to make sure a consent has been provided. I think that's just good conveyancing practice. The other point with regard to title investigation concerning registered land, if the client's title is a possessory title, is it possible to upgrade that title? Remember, it would be. If the possessory title has existed for a period in excess of 12 years, remember that it might be possible to upgrade the title sooner if whatever has caused the land registry to grant the possessory title in the first place has now been resolved or dealt with. So, for example, if there are missing title deeds or something of that nature, possessory title is sought and obtained, and then you find the deeds and documents, of course, you can upgrade that title. Other points to note relating to registered titles: be careful about land registry title plans. If there's boundary sensitivity, boundary disputes, etc., it might be important to advise a lender that the title plan is not consistent with what client is saying, agents particulars are saying, or surveyor or valuer is saying, and just warn the lender about that as an issue. Perhaps ask the lender's valuer to confirm that they've undertaken a valuation on the basis of what is actually owned by the seller, rather than the title plan, that which the title plan reveals. And the other point to note with regard to registered titles, some lenders don't like security where the title is composed of more than one registered title, so always check that. And if you are buying a series of registered titles in connection with one property, always do a SIM search of the entire site, because I'm fed up with the number of times that I've been involved in site assembly projects or been advising people in connection with site assembly projects, and it appears that there are 3 or 4 registered titles that all abut one another, and therefore you think there's absolutely no problem. And when you actually investigate, there are slivers of unregistered land sitting between unregistered titles. And when you've got that sort of problem, you get some land registry officers that take a practical approach and will just say, well, you own the land all around it, we'll just incorporate that sliver of unregistered land into your existing registered titles, tick, happy days. Or bad news and big cross, land registries say, we don't have to amend your title plan to incorporate that bit of land. Title plans are to an extent an irrelevance, and what we encourage you to do is simply hold that unregistered land for a period of 12 years and then bring a claim relating to that land to gain a possessory title at that juncture. So do watch site assembly projects where a lender is taking a charge over the entirety of the various titles, or where you're buying a residential property and perhaps the house and part of the garden has title A, another part of the garden has title B, and further additions title C and D, etc. SIM search the lot, check your lender's instructions to make sure that they're happy to lend on the lot. If there are issues with regard to boundaries, so there's a problem with regard to the extent of the land, it might be appropriate to be cautious and suggest to the lender the problem and ask a valuer to assess a valuation of what you can prove as title. In connection with unregistered land, a few points. First of all, and I dread to say this because I'll get shouted at, no doubt, problems with regard to first registration. I was talking to a practitioner yesterday who has got a title back and has been waiting for it for 3 years. I talked to some practitioners who tell me that it's 1 to 2 years that they're waiting for applications for first registration to come back. Every now and again, I get someone who tells me that their application was dealt with in 5 weeks, 4 weeks, in one situation just recently, 2 weeks. There doesn't seem to be any rhyme or reason as to why some applications are swift and some take forever. And the important thing there, I think, is if you're telling a client on first registration there's likely to be a delay, the delight in getting the application back very swiftly can often be very short-lived on the basis that the client thinks you're an idiot, on the basis that you've told him it's going to take 2 years for his title to be registered and it's back in 2 weeks. So problem number 1, in circumstances where you're uncomfortable with unregistered land or the title that's being offered to you in connection with unregistered land, do think about asking the seller to voluntary register. Voluntary registration, from what I can gather, takes place far more swiftly than applications for first registration. So if the seller has time and the seller is planning to put a property to market, voluntary registration could potentially alleviate the problem. The other issue with regard to unregistered land is do check the title carefully and make sure that you're satisfied with the title and that a land registry officer would be satisfied with it too. Remember that the residential conditions of sale, which are currently in their 5th edition, do require a seller to assist a buyer on first registration of unregistered land such that the buyer is registered with an absolute title. It's always worth thinking about that if you're encountering problems with regard to the land registry. A word of caution, however, even though the land registry may be requesting or requisitioning issues with regard to unregistered land, and even though the seller is contractually bound to assist, frequently, given how busy sellers can be and how they may not be paid for the additional work that they do in assisting you in registration, you might find a seller or a seller's conveyancer reluctant to assist. And therefore, it's important that unregistered land is considered carefully during the conveyancing process. And it's dangerous, in my view, to expect assistance from a seller once an application for first registration has gone in and you're being bombarded with requisitions from the land registry. So title investigation in connection with lenders is just as important, of course, as it is for the borrower lay client. Remember that there isn't such a thing as a collective client, and remember that it is important to think about title from the perspective of the lender. Is this adequate security? Is my lender going to receive a first legal charge over the title? And therefore, am I going to comply with my lender's instructions? One or two points to note with regard to that, really. First of all, where there are delays in registration, lenders are bombarding practitioners with regard to requests for information. It's important that those requests are dealt with. The second and important issue with regard to this is that where you are dealing with unregistered land and there are requisitions, I think it's important to keep lenders informed about those requisitions and about your dealing with them. Let's move on for a moment, if we can.
Thank you, Ian. Just before we move on to the next slide, we have a question here from Samantha.
Thank
if
you.
the lender's consent wasn't provided for a lease, but the charge is subsequently removed, does this resolve the issue?
Yes, it does. That would resolve the issue. Thank you for that question. And yeah, that would be the position. Thanks for that. Great. Thank you very much. I want to talk now about defective title insurance. Defective title insurance is useful for us as conveyancers. It gets the job done, doesn't it? But you've got to understand and appreciate that a title indemnity policy enables a transaction to proceed, hopefully, but does not remedy the defect. And therefore, it's important that when you're dealing with a defect in title, the lay client is aware of their duties and obligations to the insurer, because a lender will want to make sure that the lay client is aware of those duties and obligations, because if they are not and they default, then that could invalidate a policy and thus generate risk as far as a lender is concerned. And the second thing is to make sure that the policy is in force and that the policy covers the risk. To that end, I'm frequently worried about situations where there are pre-existing policies. Where there are pre-existing policies, I would want the buyer's conveyancer to do an audit of the policy by making inquiry of the insurer that the premium has been paid, that been no notifications with regard to claims, etc. And I'd probably want warranties in the contract from the seller, that the seller made a full disclosure to the insurer when the policy was taken out, and that the seller is not aware of any issues that would potentially invalidate the policy. The question I was asked frequently, and I was asked this question yesterday, who should take out the policy, the seller or the buyer? Well, it's the seller's responsibility to produce a good and marketable title. Therefore, if the title is defective, theoretically, the seller should remedy the defect. But there, I think, is a risk in a seller doing that, because a seller might be concerned that if they tell the truth and the whole truth to the insurer might not want to insure the risk, or the premium might go sky high. And therefore, the seller might think, well, if I hide one or two things and just take out a policy, once the property is sold, that's the problem gone. And the issue for the buyer is not an issue for me. So I think there's always that risk. And the second thing is there might be a risk that the seller genuinely has knowledge, but inadvertently fails to tell the insurer about it. So therefore, I think it's better that the seller pays the premium, or there's a reduction in purchase price with regard to the premium, and the buyer takes out the policy. The buyer then, or the buyer's conveyancer more accurately, can ensure that the policy is taken out, that the appropriate disclosures are made to the insurer, and that the buyer client is aware of what the policy is and does, and aware of his or her duties relating to it. 2 or 3 things here with regard to policies. Always check what the lender has to say. Frequently, the lender will say, well, we'll accept a policy provided that the client, the buyer client, is aware of the policy and aware of their duties and obligations, and as long as it's at no cost to the lender. Some lenders will insist that they are noted on the policy. Others will insist that the policy benefits them and is in their name as well as the client. You need to check that. Second issue, the level of indemnity. Always check what a lender wants. This is a sort of personal crusade of mine, to be honest with you, because the level of indemnity in connection with a title indemnity policy is an arbitrary sum, isn't it? You don't know if your client becomes embroiled in litigation, what sort of costs could be incurred. I mean, I don't know if you saw that Japanese knotweed case in the Central London County Court recently, but the claim for misrepresentation, £32,000, costs that our unfortunate seller is having to pay approximately £170,000 for a relatively small scale county court action. So if our client is buying a cheap flat for £130,000 or a house for £30,000 and takes out an indemnity policy for £130,000, or takes out a policy for the value or the extent of the mortgage, £80,000, how do we know that if a claim is made on that policy, the claim will be less than that £80,000 sum? We don't. Clients need to be aware of that as an issue. I repeat, the indemnity is an arbitrary sum. We do what our lender requires, but it's important to advise our borrower client about what we've done in connection with that level of indemnity. I think we need to advise borrowers that we've taken out a policy. We advise clients when we take out the policy about the duties and obligations that they owe to the insurer, and also inadvertently or indirectly that are owed to the lender. And we also remind a borrower client when we're closing our file that there is a policy and there are ongoing duties and obligations that the borrower owes in connection with that policy that will protect the borrower and also protect the lender. The final thing with regard to title indemnity policies that I want to share with you is the fact that be careful about where properties are sold at auction, either face-to-face auction or online auction, in that if a title indemnity policy is included in an auction pack, theoretically that would constitute disclosure to the world at large that would potentially invalidate the policy. So we need to be careful. Next thing I want to talk about are lenders and land registration. And there's a number of points here. First of all, it is essential that in order to comply with lender instructions that we check that there are appropriate easements sufficient to enable the client's object, the borrower client's objects with regard to acquisition. If there is a situation that there aren't sufficient easements to facilitate our client's objective, or there aren't sufficient easements to enable a reasonable use of the property, then lenders need to be made aware of that fact. As far as easements are concerned, we also need to think about not just whether there is a right of way, a right to park, a right to store, a right to connect to drains, rights to light, etc., but in particular with regard to rights of way, rights to store, rights to park, what about repair and maintenance issues? Does the easement deal with those? We also need to be careful about whether or not there are any easements that impact on the use and enjoyment of the property that is being used by a security by a lender. So are there rights of way over the land? Are there legal easements that are rights of way? Are there prescriptive easements that are in essence overriding interest, but which nonetheless would be binding on a buyer and or a lender after acquisition? To that end, I think it's important that we read carefully any lender's valuation or survey that's available to us, and we also check carefully what our client has to say with regard to any inspection that they undertake. And if there are issues relating to anything that could constitute an overriding interest that would be binding on a buyer client, we need to be aware that that could also be binding on a lender if a lender was to take possession of the property as a consequence of borrower default. So we need to be careful with regard to that, in my view, and the consequences of it. Same thing with regard to covenants. If there are covenants, it's important that we assess whether those covenants impact on security. Again, if I've got any doubts, I would ask the lender's surveyor or valuer to comment on the issue, because the covenant, if enforceable, might have valuation issues. It's important that we tell our lay client buyer to keep addresses for service up to date. It's also important that we check a seller's address for service as against any information that we have on our file in connection with the seller. One of the things that we can connect in connection with property fraud from cases such as Purensing and Dreamvar is if there's a mismatch between seller's address for service and seller's contact details, that is an indicator potentially of seller identity fraud. The seller's client's identity fraud issue should be addressed by the seller themselves when onboarding the client. But if we're acting for a buyer, again, we just need to be aware of that as a potential problem. I mentioned adverse possession on slide here. Again, I would always report to a lender if there's the slightest hint of adverse possession that is current, live, and active, or where there has been adverse possession claims being lodged in connection with title historically. The reason I would mention historical adverse possession claims is that if there has been such a claim, even where the claim has been unsuccessful, if the adverse possessor remains in situ, he or she is entitled to make a second claim and will be successful upon conclusion of that second application. I mentioned boundaries, and I've dealt with that already. Be careful about making sure if there are boundary sensitivity issues that could impact on use and enjoyment of the property from both the borrower and lender's perspective. So we need to make sure that we have access to the property directly from a highway, that there aren't any ransom strips. We need to be careful to make sure that there haven't been any alterations to boundaries, etc. And if there have been, our client lender needs to be made aware of it, as does the lender's surveyor or valuer. The other point to note that I think is important here that I mentioned on slide, and this applies across the board to lenders and borrowers, buyer clients, notices. Just because a notice is registered on a registered title does not validate, legitimize, or guarantee the existence of an interest in land. It is simply a statement that someone contends that they have a valid interest in land and the land registry has been willing to accept their application. So a notice protecting a restrictive covenant does not validate the restrictive covenant. A notice protecting an option agreement or a lease, for example, would not validate the existence of that lease or the existence of any other interest in land. It's therefore necessary to either report to lender or investigate, looking at the application and any documents submitted in support, whether or not there is in fact a valid interest in land that exists. Remember, notices that are unilateral notices can be challenged and can be removed. Agreed notices are, generally speaking, subject only to cancellation or an applicant withdrawing them. All of these things, as I say, need addressing and considering when acting on behalf of lenders. The issue with regard to an easement, for example, over land could affect value. A restrictive covenant over the land might not impact on the buyer client's objective, but might be an issue for the lender. The other thing to mention just before we leave this point is what happens if the land that a lender is using as security has the benefit of a covenant over other land. Well, the existence of that covenant and or its enforceability might again be an issue for valuation purposes. So where we have issues with regard to restrictive covenants that burden the land or benefit the land, it might be necessary to say to the lender or the lender's surveyor or valuer, hey, look, are you aware of this, and does it impact on your view with regard to the value of this land for security purposes? In short, I think it's always better to report to a lender, even though I concede the lender's likely response is, thank you for telling us, but we're going to rely upon you in connection with your certificate of title, and you're representing us in connection with whether what you've identified is an issue for us with regard to our security. Next thing I want to talk about in acting for lenders is the issue of undue influence and improper pressure being exerted on clients, leading to clients to commit themselves to transactions, and to what extent that conduct or misconduct can impact on lenders. Certainly, where undue influence is established, it can mean that a lender's security is against the person that's been subjected to undue influence is lost. It's also settled law that you and I, as conveyancers, owe a duty not only to the person suffering undue influence, but also to our lender clients to make sure that undue influence is not present in connection with the transaction, or if it is, it's reported to our client, and also reported to the lender. So, 2 or 3 things here that I want to share with you. Firstly, if you look at recent decisions of the SDT, Solicitor's Disciplinary Tribunal, you'll see quite a number of cases arising from misconduct due to a failure on behalf of the conveyancer's solicitor to check the capacity, the status, the awareness of the client. And I think this is down to the fact that we're not seeing clients the way we used to. They're not popping into the office to sit down and sign documents or to discuss the report on title, etc. We're doing it virtually, or we're doing it by email. But there was one case recently where a lawyer was fined £10,000 on the basis that a client selling a property had a mental age, I think, of 12, and was selling the property at a gross undervalue to someone that he knew that it was an accountant. And another case just recently where, again, an elderly client was transferring property out to members of her family, some close and some distant, and again wasn't aware of what she was doing or the consequences of what was being done. Solicitor in that case fined £15,000. So I do think it's important that, as the SRA advocate, as CQS guidance advocates, that we know our clients. I was talking to someone about this earlier in the week, and what they were saying is, is it good practice that we try and have at least some form of virtual meeting with the client, and where we're concerned about undue influence or its risk, or concerned about capacity, we can ask questions, or we can ensure that the client is alone when we're having our virtual meeting, just to attempt to satisfy ourselves that there isn't anything untoward. Remember, there's no such thing as a collective client in this regard, and that there could be undue influence being exerted by one co-owner against another. And therefore, again, it's important to consider that issue when dealing with co-ownership. And remember, and the point I want to labour and emphasise this morning, is the fact that our lender client could be bound by any awareness that we have relating to improper pressure or undue influence. The Ettridge guidelines are well worth a read and look over from time to time, particularly for junior members of staff where we're supervising, just to make sure that everyone is aware of risk assessment with regard to conflict, risk assessment with regards to fraud, risk assessment with regards to the potential for undue influence. My philosophy is that we shouldn't be acting for guarantors in residential conveyancing transactions. They should be advised independently. With regard to high-risk transactions, we should be undertaking further checks and controls with regard to the file. That we need to be aware of the fact that where there is anything untoward that could generate undue influence, that will have implications for the lender on the basis that they will have constructive notice of impropriety due to our awareness. A number of things really to flow from this. Again, if you're concerned about something or not sure about something, you've got a compliance team, you've got line managers, etc., in which a discussion can take place, or with which a discussion can take place about the problem that you've identified. Further, it might not just be one isolated incident that sounds alarm bells ringing. There could be a series of incidents during the life of your retainer that cumulatively could warrant further investigation or issues. And the other point that I think is so important to make, it isn't enough to do a risk assessment with regard to conflict, with regard to undue influence, with regard to capacity, with regard to fraud at the start of the transaction. It is important that we are constantly alive to all of those issues during the lifespan of the transaction. I know we've got another question there. If you could tell me what that question is, I'm happy to deal with it at this point, if that's possible.
I'm not sure what they're referring to, but they're asking about the notes. So if you could just clarify what you mean, and then we'll get that on.
Yeah, what we'll do, there are notes that accompany the presentation, which we'll send out to delegates after the presentation, if that's all right.
Okay.
Yeah, that's lovely. Thank you. Good. Okay. Law Society guidance on undue influence was issued back in 2002. Again, important that we make sure that there aren't conflicts of interest between lender and client or between clients. We obtain sufficient information from all clients to provide advice, and that we can ensure that clients understand the advice that we're providing. A number of points here that flow from this. With regard to clients, it's important that we provide information and explanation, and that we highlight risk. And in connection with clients, it's important that we know our clients or attempt to know our clients, and we are aware that where there are issues with regard to the lay client, on the basis of constructive notice, that can impact on the lender. And therefore, we do need to take into account not only the repercussions professionally for us, but also the repercussions for the lender too. Conflicts of interest we've got to be careful with. We almost have to appreciate that in any residential transaction, when acting for an institutional lender and the lay client, there is a substantial common interest, namely the acquisition of a good and marketable title. There can, however, be a divergence from time to time in connection with lenders and our borrower-buyer clients. It's important in those circumstances that we ensure that the borrower-buyer client is aware of the constraints that are imposed on us with regard to the lender. Frequently, this sort of battle is between the client who wants to proceed and our concerns with regard to protecting the lender can lead to dissatisfaction from the client, the lay client, the buyer client. And therefore, what I suggest is when you're onboarding the client, when you're scoping the retainer and you're acting for a lender, it's important that the client has spelt out to it that relationship and the fact that, in essence, without the lender's cooperation and willingness to proceed, the transaction is doomed to failure. The other thing that I think is important to clarify right at the start of the transaction is, in order to deal with issues concerning confidentiality, to make clients aware of what information on the file belongs to the lender or would need to be disclosed to the lender, and to ascertain where a mortgage offer is received from a lender to the borrower, whether in accepting that mortgage offer, the borrower is releasing itself from some of the confidentiality constraints that would normally exist. I mentioned this issue of informed consent. Clients can only consent to proceed, can only consent to the release of the confidentiality duty that exists to us if they understand the significance of that duty. Areas of risk with regard to conflicts of interest, of course, the lender buyer client is an obvious risk. Co-owners, again, so important. Co-owners are not a collective client. So when you're dealing with the co-owner buyer client, it's important that they understand and they are provided with your engagement letter. They're provided with a report on title. They are aware of the loan facility that your client lender is offering and is aware of the duties and obligations that you owe to the lender. Frequently, you might have one party in a co-ownership scenario that is taking the lead with regard to the transaction, particularly with regard to lenders. Given what we said earlier about risks of undue influence, etc., it's important that both clients are aware of our duties and obligations and aware of the facility that's being offered by the lender and the duties and obligations that are owed by the borrowers to that lender. Moving on, if I can, confidentiality we've talked about. The position with regard to the conveyancing file. There's now accepted case law that certain papers within the file belong to the lender or are jointly owned by lender and or borrower. It's important that you are aware of that position, and you're also aware that the position could be modified by whatever the lender and borrower have agreed with regard to the file. So some lenders will insist in the borrower accepting the terms of a mortgage offer that the entirety of the file can be released to the lender or provided to the lender where circumstances require it. Which leads me to legal charges and how we advise the client. Whether the legal charge is being executed independently of us or being signed in our presence, it is important that the clients understand the nature of the charge and the fact that that charge ultimately will secure the loan on the property that the client is acquiring. The client needs to be made aware by you of the risk and consequences of default, needs to be aware of the purpose of the loan facility, the terms of the loan, the security being offered, and the value of the asset being given as security, unless that information is also already being volunteered by the lender. 2 or 3 things that I want to share with regard to this point. It isn't necessary in most circumstances to advise the client as to the nature of the loan or facility that's being offered. But if the loan or facility is so commercially unwise, there is a requirement for a conveyancer to step off the fence and say, hey, should you really be doing this? There are lots of cases in connection with sales and leaseback, etc., where the courts are saying this deal is so bad that the client should have been told that it was a bad deal and perhaps told to revisit the deal and have a look or a think about doing something else. And I think this is important. In what I would class as a standard institutional lending situation, it isn't necessary for you to explore the deal, and it's certainly completely out with your retainer to give any advice concerning the product that's being offered. But let's assume that the client is being charged an exorbitant and ridiculous interest rate. Let's assume that there are other clauses within the terms of the mortgage advance that are so ridiculous as to be completely uncommercial from the client's perspective, given their circumstances. It is important to tell the client what you think and to suggest to the client that they get advice elsewhere as to alternatives, alternative funding, alternative ways of dealing with things. Again, I'm noticing there's another question in the Q&A. I'll just see if I can answer that. All right, here we go. Chris, are we heading towards a point where it might be preferable for all lenders to be separately represented and for all significant conveyancing transactions to have the benefit of title insurance as standard? Very interesting point, Chris, and I could talk about that forever, to be honest with you. My view is that as we get more and more obligations imposed on us as conveyancers, the safest thing would be separate representation. On the issue of title insurance, again, title insurance is useful, but as I say, it doesn't resolve the problem. It's a solution, but it's not every solution. Someone is saying, I couldn't see the notes, they will be provided after the event, the notes, because I've sent them to InfoTrack and they will be made available. If there's a problem, drop me a note and I can get them to you anyway. Laura, independent guarantor advice. Must guarantors always be sent to a separate firm for advice? Can they go to another branch of the firm where the firm has another branch? Laura, potentially you can act where there are glass ceilings, but I would always be wary about doing that, to be honest with you. I think there is the danger of a risk with regard to conflict, with regard to a guarantor. What benefit is a guarantor receiving from acting as a guarantor would be my question, Laura. Maria, we're able to set a retainer to clients as to what we're doing and not going to do. You can't with lenders. No, that's the problem, isn't it? That's the nightmare, as we'll see in a moment or two before we finish. Okay, I think you can get a copy of the recording as well. Yeah, I'll move on. Thanks for those questions, everyone. That was great. I'll just get rid of those if I can. Bear with me. Right, so let's just have a look now if we can slide again. So with regard to legal charges, just be aware of the fact that it is important, insofar as you are able, to offer some advice with regard to the legal charge, and in particular, the risks associated with default. Okay, next thing I want to talk about is estate rent charges. And the issue with regard to estate rent charges is as follows. Estate rent charges, or rent charges generally, have created huge problems for lenders. And the reason for that is section 121 of the Law Property Act 1925, which enables a rent charge owner, where a rent charge payer is in default, to utilize the creation of a lease that can be registered against the rent charge payer's title as a means of enforcing the rent charge debt. So what some rent charge owners have done in the past is there's been a nominal amount of rent charge owing, £10, £5 or something of that nature. The rent charge owner has thought, well, it's uneconomic really to collect that amount each month. But what we can do where a rent charge payer has not paid us is instruct lawyers to create a lease, register that lease, and then insist that the rent charge payer not only pays the amount of rent charge, the £5, the £10 or whatever the payment was due, but also pays all our legal costs associated with the registration, the creation of the lease, registration of the lease, and its removal. The problem with the creation of the lease is that the Law Property Act 1925 allows that remedy to be utilised. It also is a problem in that the lease that's created blights the rent charge payer's title and also blights the lender's security. So it's absolutely essential that you check your instructions in connection with lenders to make sure what their stance is with regard to rent charges and estate rent charges, and that you warn your lay client about section 121, and you also check what your lender's instructions are as to whether or not they're willing to accept the title that's being offered with such a rent charge. 2 or 3 things to note here. Firstly, an estate rent charge is not the same as a rent charge. A rent charge is subject to the Rent Charges Act, which means it can be bought out or apportioned where it is divided between properties. An estate rent charge cannot be bought out. An estate rent charge is normally linked to some form of covenant, some form of positive covenant, and is used more and more these days because leasehold houses can't be built or sold as leasehold, and where developers are building sort of private gated estates where roads and footpaths are not being adopted. Developers are therefore left with a situation where they've got an ongoing expense with regard to repair and maintenance, and in the past they would have created leases with common parts and service charge. Now they can't do that. They are creating estate rent charges for the recovery of cost. Some lenders will allow a property as security if the rent charge or the estate rent charge has a number of provisions within it, namely that section 121 of the Law Property Act 1925 doesn't apply. You can exclude the operation of section 121, by the way, or that the rent charge has to be formally demanded and notice has to be served on a lender where it has been demanded and remains unpaid. You can also include provisions for the estate rent charge to be subject to a test of reasonableness. You can require the provision of accounts, etc., to be produced before a formal rent charge demand is made. But at the moment, there are problems with regard to estate rent charges that are as yet unsolvable or unresolvable, because developers are insisting that they want estate rent charges. Some are being reasonable and excluding section 121 or are allowing amendments to their documentation to meet lender requirements, but some are not. Just be alive to that fact, please, and just be aware of it. So I've mentioned here what a rent charge is. The peculiar thing about a rent charge is it doesn't have to be called a rent charge to be so. It's any annual or other periodic sum charged on or issued out of land. It can relate to leasehold property just as much as freehold property, and you can have a situation with regard to a rent charge that is outside the scope of the Rent Charges Act, estate rent charges being the obvious thing. So in short, be careful about making sure you're complying with lender's instructions. Notify lender if you are dealing with an estate rent charge and you've got a developer or builder that's not playing ball. James, thank you for your question. Yeah, I would, James, I'm worried about this, where people are saying this isn't a rent charge for the purposes of the 77 Act. And I would always want, in addition to that, section 121 being excluded. Lender Part 2's requirements on this here are an absolute minefield. I agree, James. To be honest, I could speak all day about rent charges and estate rent charges and what to do and how to do it. What I've tried to do on slide here is just giving you some ideas. How do you spot one? In essence, a rent charge is an interest in land and therefore should be protected by notice in the charges register of the title of the rent charge payer's title. It can apply to freehold or leasehold, it can be legal or equitable, and it can be an annual payment or a periodic sum. And therefore, just because something is not called a rent charge doesn't mean that it isn't one. Moving on, if possible. So what do you do? I think if you've got an annual or periodic payment that's due in connection with a freehold or leasehold matter, in the connection of leasehold, it's not a service charge, I would presume that it could be a rent charge. Tell the client that there's no cap on the potential liability relating to a rent charge. There's no opportunity to challenge rent charges on the basis of reasonableness. And the other point is, unlike service charge, even if a rent charge was unreasonable, it still is potentially enforceable. There's no obligation on a rent charge owner to demand payment or remind rent charge payers of non-payment, unless the rent charger specifies that point. And remedies for rent charge owners are excessive, given how frequently the amount that is attempted to be recovered is small. Two or three things I think are important relating to this. Firstly, I think you give clients advice about rent charges generally. The Association of Residential Managing Agents has a leaflet for clients on rent charges. Second thing, I think you must warn clients that, unlike in leasehold situations, there isn't statutory protection for rent charge payers yet. And as far as I can gather, there doesn't seem to be anything in the middle or near distance, as far as government is concerned, to redress that imbalance. The government have said and have mooted legislation to afford freeholders the same protection as leaseholders with regard to this type of payment, but as yet that isn't in law. So there are problems with regard to rent charges, and you've got to advise lenders of that fact. So we've covered those points off, so we needn't worry about that. Interestingly, if a rent charge hasn't been paid for a period of 12 years and hasn't been demanded for a period of 12 years, it is possible, that's for unregistered land, 10 years for unregistered land, to claim adverse possession of a rent charge. Never heard anyone do it, but just be aware of that. I want to finish today by talking about the Building Safety Act. And again, in the notes, I highlight some problems with regard to landlord certificates and leaseholders' deeds of certificate. The Building Safety Act 2022 is a huge piece of legislation that has wide-ranging application for any leasehold property where there are two or more residences within a building. But where it becomes particularly significant is where we have a building of 5 stories or 11 meters in height or more, because that would trigger the need for a landlord certificate and a leaseholder's deed of certificate. The thinking behind both of these documents is that a landlord certificate is an indicator to the leaseholder or subsequent leaseholders of the fact that landlords have incurred remediation costs relating to building safety, not just fire safety. If a landlord is required to issue a certificate and has failed to do so, then the landlord is prevented from claiming remediation costs from leaseholders. So a landlord should issue a certificate with service charge where remediation costs have been incurred, should issue a certificate when required to do so by a leaseholder, and should issue a certificate when a leaseholder is selling their leasehold interest. A leaseholder deed of certificate can be produced at any time, but the idea of a leaseholder deed of certificate is in essence self-certification, stating that I am a leaseholder and I am, or the owner of the property was, as of the 14th of February 2022, protected by the Building Safety Act. The consequence of that is the landlord, in connection with the building, is obliged to attempt to recover costs relating to remediation from contractors or builders who did the initial work for which remediation is required, is then required to pursue any form of compensation or scheme that's available to him or her via government, and then and only then, as a sort of default position, can claim costs from leaseholders subject to a cap. The problem that I have with regards to landlord certificates and leaseholders' deeds of certificates, anonymous, the Association of Residential Managing Agents, or ARMA, is where you get a rent charge leaflet for clients. Sorry about that. Anyway, going back to this, the problem with the Building Safety Act is that we are reliant on the landlord to produce a certificate and the leaseholder to produce a certificate containing correct information. It came into force last year. Not all of it is in force, Peter. Okay, if that answers that question, thank you. So the problem I have is that if you have a leaseholder that self-certifies that as of the 14th of February 2022, they were in occupation of the property and this was their main and only residence, or that they owned the property and they had less than 3 other properties of a similar nature within the United Kingdom, if a leaseholder says that in the deed of certificate, a subsequent buyer could rely upon it, thinking then that they've got the protection of the Building Safety Act. What happens if the leaseholder who produced the deed of certificate gets it wrong? Well, then you've got theoretically an action for misrepresentation. What happens if the conveyancer for the leaseholder assists in connection with the production of the deed of certificate and assists in providing misinformation or false information? No problem, Katie. I'm sure that InfoTrack will sort this out. I'm sorry about overrunning. I've got 1 or 2 things to say before I finish. So in short, my view is you shouldn't be accepting leaseholder deeds of certificate where you're acting for a lender, because the lender may ask you to verify its content. If the seller has 3 or more properties, Mohammed, the Building Safety Act doesn't apply. I think the government thinking is that leaseholder has sufficient means and sufficient assets to meet the remediation costs that are now incorporated into service charge. So that's the reason for that 3 or more property point. Great, I'll just kick on if I can. The Building Safety Act isn't finished because it's not fully in force. Lenders' instructions, in my view, are completely unreasonable. There is risk to conveyancer for the seller and the buyer, and risk to the conveyancer acting for the lender. And what about advising landlords or managing agents or management companies with regard to information that they're producing, LPE1s with landlord certificate, leaseholders, deeds of certificate, etc., where that information is incorrect? The LPE1, ARMA has given some guidance about and has asked that ARMA registered managing agents put a disclaimer in the LPE1 so that they're not liable for misinformation. The LPE1 will include now leaseholder deeds of certificate, landlord certificate, but as I say, will not generate liability for errors. I'll come to your question in a moment, Kate, if I might. So the Building Safety Act is a problem for shared ownership leases, problem for acting for lenders. So I'm just going to skip through, because there's 1 or 2 things I've done in the slides here. I've looked at each of the lenders that you're likely to deal with and shown you what they want from you. You must tell us before completion if the current owner is a qualifying leaseholder. Send us a copy of the landlord certificate, etc. Well, all right, we might be able to do that. But if you have a look at Barclays and Nationwide, they're asking you to certify that the information in the leaseholder's deed of certificate is correct. And that's really scary. Conscious of time, so I'm going to finish. Have a look at CQS guidance when acting for lenders and performing risk assessments. And now, if we can deal with some questions. Would it be better if Annabella does a presentation and then we deal with questions if there are any at the end? Because I am conscious of time and the fact that I've overrun. Would that be all right?
Yeah, Annabella's just going to jump straight into it now.
Okay, lovely, thank you.
All right, thank you, Ian. Okay, so before we start our Q&A, I'll just quickly run through the features that we have built into the InfoTrack platform to help you stay up to date with the UK Finance Lenders Handbook. So this is your InfoTrack home screen. On the left, you've got your dashboard, in the middle are your current matters, and on the right-hand side, your news and calendar. So we've set out a workflow which is separated into modules, and the Lender's Handbook is available in the bank check module. So we've been integrating with UK Finance for a couple of years now, and we've added several features to help you meet your requirements. So when you open the handbook, there are 3 tabs at the top. You've got the handbook, search for updates, and manage my alerts. So the handbook tab allows you to view parts 1, 2, and 3 of the handbook for all lenders in England and Wales. Simply select the lender and the parts you would like to view and click search. You can scroll through, or using the content section on the left-hand side, click on the question you would like to view and you'll be navigated straight to the answer. And we also have a handy search bar so that you can look up keywords. So for example, if you want to check whether the lender stipulates anything relating to doubling ground rents, you can just type doubling into the search bar. And then all questions and answers which refer to this within the parts you have selected will be shown and your keyword will be highlighted. And we monitor the handbook throughout the day to check for updates. And one thing that we notice being changed quite frequently is the new build warranties. So if we type warranty into the search bar, we can see what this lender currently accepts. And then likewise, if we search for indemnity, we can see all questions and answers which refer to this. And we have spoken to firms about how they use the handbook, and a lot of them explain that they need to save the lender's answer to their matter, both to demonstrate that it has been checked and also to capture the requirements at that time in case they change. So to help with this, we built the review feature, which will allow you to select any or all of the answers under parts 1, 2, and 3 and save them to your file. So under the content section on the left-hand side, you can tick individual answers or entire sections, or you can select all, and then click in the bottom right, save the matter. The pop-up will just ask you to confirm that these answers have been checked, so click confirm. You'll then be redirected to your matter viewer where the review document will be shown. So the document will show who conducted the review, the lender, and the dates of the first and last review. So this will help you to meet the requirement under the core practice management standard to record on your file that the handbook has been checked. And we've designed this to be flexible and fit with your process by allowing you to add to your review. So for instance, if you need to check separate sections at different stages of the transaction, all reviews will be contained in the same document. And the review can also be added to by others. So where more than one person has reviewed, all of their names will be listed at the top of the document. Underneath each answer will only show the person who has reviewed that answer. So to continue your review, just click Review Handbook in the top right. And then we'll also show you which answers have already been checked here, so that you don't need to refer back to the review document. So you can check this by expanding the contents on the left-hand side. And if an answer has been reviewed, we'll show the date last reviewed. And if the answer has been changed since it was reviewed, we'll also show a little alert here as well to prompt you to check it again. And then for each answer, we also show the date that it was last changed. So if we search for ground rent, here, we can see that this particular answer, 5.14.9, was last changed on the 6th of January this year. So if you need to know what the previous answer was, this is where the search for updates comes in. So select your lender from the drop-down. And then you also select the search from date here. So we'll pre-populate this to approximately 6 months before today's date, but you can move that back or forwards if you need to. Click Order and we'll return the report instantly, showing full details of any changes made. So the document will include the previous and the new answer so that you can compare them and the date of the change. So in this case, we can see that 5.14.9 was also changed on the 5th of September last year. This is the previous answer and this is what it was changed to. So we can see that one of the clauses around ground rents doubling after 125 years was removed. And then several other changes have also been made in the last 6 months. New questions were added to Part 2 in December for the Building Safety Act. And then further information was added to multiple answers, including conditions relating to properties let at completion and new builds. And then on the 6th of January, 5.14.9 was changed again when Barclays added information relating to the Leasehold Reform Act. So on this date, 2 new questions were added, and then 6.6.1 was also changed again. Here we go. So far this year, we have seen 28 lenders make a total of 76 changes. So with so many changes being made, we know that it can be difficult to stay up to date. So to help you with this, we've also got our alert service. So if you go back to the handbook, the third tab at the top is Manage My Alerts. So here you can sign up to receive alerts for any or all lenders. So just select which lenders you want to receive alerts for. And then in the bottom right, click Update My Alerts Preferences. And then what this means is we'll send you an email when the lender makes the change so that you can be proactively updated to that. So here's an example of an email that we sent on the 6th of January showing those changes made by Barclays. So we highlight the differences between the answers as well, so you can easily see what has been removed and what has been added. So on this day, we also had Nationwide and the Mortgage Works making changes. Just find those here. So they added some instructions around Mundic reports, you can see here. So hopefully you'll find these features helpful. And I'll now hand back to Haifa for our Q&A.
Thank you, Annabella.
Thank you. Okay, so we'll just jump straight into the questions. Ian, do you want to?
Yeah, I'll go through them if I may. Thank you. First of all, Trish, elaborate on the problems with shared ownership leases. The Building Safety Act does a number of things. First of all, as I mentioned, it enables someone that's sort of owner occupying a flat or apartment to be protected if they were in ownership or occupation as of the 14th of February. It ensures that persons that are buy-to-let investors that have more than 3 properties are not protected by the Building Safety Act. If, however, you are in owner occupation of 1 and you have more than 3, the Building Safety Act will apply to the one that you're actually living in as of the 14th of February. If the leaseholders are collectively enfranchised, so in essence, the leaseholders are their own landlord, then the Act doesn't apply. If, however, they've obtained the right to manage, then the landlord still is the landlord and the Act does apply. In connection with shared ownership leases, Trish, the problem is, who is the landlord? And again, as far as shared ownership leases, there's some dispute as to whether the Act applies or not. I'm working on that at the moment, Trish, and what I'll do is share with you what I find out ultimately. But at the moment, the position is a little bit confusing, and therefore a lot of people are saying, well, a lot of people are saying generally, we're not going to act on a sale or purchase in connection with a property that could be subject to the Building Safety Act. On the basis that there's too much vulnerability potentially for claims being brought against us with regard to leaseholder deeds of certificate and landlord certificates, and also what sort of advice should we be giving clients. Anonymous attendee, does the Building Safety Act apply to ex-council properties? It could apply potentially to all properties. It will apply to any property where there's more than 2 residences within it. Some of the fire safety legislation will apply to buildings, any building, as long as there are more than 2 residential units with it and their common parts. The Building Safety Act applies to all buildings, but then there are additional constraints, additional obligations if we're 5 stories or 11 meters in height, and additional obligations apply in connection with 8 buildings that are 18 stories or more in height. If you want to know how you calculate the height of a building, there's some government guidance on that relates to it. Right, yeah, the rent charge leaflet, if you drop me a note, Johanna, I can send that to you and share it with everyone else as well. Mohammed, I don't know, I'm happy to assist with regard to LP1 packs if we want a webinar on that at some point in the future. Anonymous, I have for a buyer no mortgage, according to, just bear with me, according to, I've lost him. Where are we? Right. Act for a buyer, no mortgage. According to the estate agent's particulars, the building appears to be 6 stories high. I've asked sellers solicitors to reply at the following. Reply to question 821 of LP1 is probably 18 meters or taller. Please run your survey or inspection. No survey carried out. How do I respond to that? Well, the point with regard to height is you can, I think on Google, there is a facility that enables you for any building to be told what the height is. And also, Anonymous, there is some government guidance relating to it. Where a landlord is of the view that it isn't necessary for them to produce a landlord's certificate, then in essence, the landlord is disadvantaged on the basis that it can't claim for remediation costs within service charge. So the fact that the landlord certificate isn't available isn't necessarily a problem. The fact that the leaseholder's deed of certificate isn't available on the basis the landlord or the current leaseholder is saying it doesn't apply to this building, that's more problematical. If a landlord is unwilling to produce a landlord certificate, and if a leaseholder is unwilling to produce such a certificate, there are theoretically sanctions available for the landlord under the Building Safety Act, but I haven't heard anyone taking action in that regard. I think if there is action that's taken, it's taken in the first tier tribunal. Right. I think what Annabella was saying is really useful, Chris, about the InfoTrack system, because what you're doing and what they've done with regard to this program is enable you to comply with the new CQS guidance, namely that you're required to check lenders' instructions before you exchange. So as Annabella was showing you there, what you can do is do your check when you first get instructions from the lender and then review the check courtesy of the system that InfoTrack have introduced just before you exchange. And you can prove that you've done it, which is the important thing. Danielle, would you recommend not acting for buyers if the property is classed as a relevant building? Yeah, can I tell you at the moment, most conveyancers won't act, Danielle. If you were going to act, I think you need to be very robust with regard to your retainer, telling the client exactly what you're not going to do. And also, I would be charging the client a lot more for the work that you are doing in connection with this issue. Annabella, someone's asking, is there a fee for the handbook check?
Yeah, so the only part of the handbook that has a fee associated is the search for updates. So that's where I showed you where you could see what the previous answers were. Yeah. To view the handbook itself and to save it to your matter and create that review document, there's no fee for that. And there's also no fee to sign up for the email alerts either.
Thank you. Andrew asks, is a contract deed of covenant-based estate service charge different to an estate rent charge? The answer to that, Andrew, is quite simple. It could be. So I would always err on the side of caution and warn my lay client and lender. Okay. Let's have this next one. Sorry, I'm just going to nip back up there if I can. Anonymous again. All certificates, in addition to the FRA, EWS1 and asbestos reports, they are different, Anonymous. Yeah. If the building is a relevant building, then you've got to go down the process that I mentioned briefly. Is it the responsibility of management? Not in the lease. Does that? If the responsibility of management is a residence management company, not the RTM under the lease, does the act still apply? If there is a landlord, Anonymous, it does apply. Yeah. Fire Safety Act then apply to HMOs. Building Safety Act, does it apply? Answer, yes. When did provisions of the Building Safety Act come into force? They came into force in June in part, and there are still parts that are not yet in force. Anonymous, the amount of floors in a building where the Building Safety Act applies to vary with each source, ranging from 5 to 7. Yes, it does. Anonymous, there are different levels of obligation on the building owner. But once you get over 11 meters in height, that's when the leaseholder certificate, leaseholder deed of certificate, landlord certificate comes into play. No fixed rent charges. It's still a rent charge for section 121. No fixed rent charge. Yeah, the section 121 would apply to that, Anonymous. Jacqueline, landlord is no member of association. Articles of association due to vary ownership in life. What are the risks? What are the risks to the lender? Is it difficult to obtain insurance? Tricky one, Jacqueline. Drop me a note by email. I'll have a go at answering that one if I can. Many deal with shared ownership. I can answer that one, Anonymous. We're working on it at the moment. I'm doing some work with a guy called Andrew Butler from Trinity Chambers, from Tanfield Chambers on this. And there's a webinar, I think, that we're going to produce towards the end of the month. So I'll let you know, and I'll let InfoTrack know about that. And as I say, there'll be some information flowing from that that might answer the shared ownership issue. Jacqueline, last question. Lender Barclays, but the buildings which contains more than 2 flats is less than 5 stories. Do you think there's a risk to our practice if we continue to act, especially in the view of the Building Safety Act? Jacqueline, I think it's where we're above 11 meters that the real problem lies, okay? I think the important thing to understand and appreciate is that the lay client needs to be aware that there are fire safety issues and some aspects of the Building Safety Act that would apply to such a building. And the only thing that worries me is that the fire safety issues could potentially invalidate insurance. So what I would do, Jacqueline, is I'd be happy to act, I think, in that situation, but I'd want the society or lender's valuer to confirm that fire safety measures are in place that are in accordance with the Building Safety Act 2022. Is that okay? I'm conscious of time, and I think we've dealt with all the questions that have come across so far, haven't we? So if there are any further questions, do feel free to drop InfoTrack a note, and I'm sure we'll pass them on to me. If I get any questions, I'm happy to share those with you. The other thing that I've done is I've prepared a little diagram about how the Building Safety Act operates, which I'm happy to share with people too. So what I'd like to do, if I may, is thank everyone for attending today. I'm just going to have a look. I think there's any more questions. There are another 3 questions. The Building Safety Act could apply to townside flats, Katrina. Yeah, it could. And yeah, we'll get this Buildings Safety Act diagram across to people so you can have a look at that. Okay, shall we finish?
Yeah, thank you so much, Ian, and thank you, Annabella, for joining us today. Just as we said earlier on, this webinar is being recorded, so we will share the recording with you guys tomorrow, and we hope you have a lovely rest of your day. Thank you, everyone.
Bye-bye.
Thank you, Ian.